I would like to introduce to all of you the moderator for our next panel discussion, Mr. N.K. Dilip, Partner, Tatva Legal. Mr. Dilip practices in the areas of corporate and commercial laws. He has experience in investments, both domestic and international, mergers and acquisitions, onshore and offshore, corporate restructuring, employment laws, private equity, project finance, and related negotiations and documentation. He has substantial industry-specific experience in the areas of private equity, retail, hospitality, infrastructure, real estate, including townships and SEZs, financial services, information technology, funds, education, and healthcare, having handled several transactions in these sectors. Mr. Dilip has also industry experience of the venture capital and retail sectors. Please put your hands together to welcome Mr. Dilip on board.
Hi, everybody. Divya, thank you for the nice, fantastic introduction. So today will have, I think our panel has gone through multiple changes. First, let me introduce and welcome on board Tejal Patel. She is GE India General Counsel in charge of South Asia. Tejal has got more than, first of all, Tejal is a very old friend, has more than 25 years of experience. Started her career in Vadya Gandhi, then was with, for a short period with Tucker & Tucker. Thereafter was in-house with GE for a long time. In-house in GE in Tokyo, in-house in GE, head of GE Healthcare Legal for Southeast Asia in Singapore. Thereafter, now at present, head of India, GE for the GE Group. She has obviously done in M&A across jurisdictions, across sectors. GE is we all know GE is like the, what shall I say, the replica for the US economy, and GE could also be the replica for the for the world economy. So she has experience across all sectors. Let me also welcome Vijay on board. Vijay is the General Counsel for OnMobile. He's been a corporate general counsel with more than 15 years experience, predominantly as in-house attorney in the domains of manufacturing, retail, and telecom in vertically integrated organization. He's presently director, legal and compliance with OnMobile, a listed telecom services company with global presence. Previously, he has been associate vice president, legal and secretarial at Lifestyle, at Himansika Seed Limited, Madura Fashions, Tyco, Mitsuyu, and WS Group Chennai. He has multinational experience in complex contract negotiation and management, corporate affairs and governance, commercial laws, litigation, license, regulatory, M&A, intellectual property, and the like. He holds a bachelor's degree in commerce and law, and is a company secretary and a chartered accountant. So he has all facets rolled into one. He's also a diploma in applications programming and has contributed articles in professional journals and has spoken at various professional forums. He's a visiting faculty with ICFI for CFA and MBA. Some of his articles included role of morality and estoppel in delivery of justice, cloud computing, monthly, and he also contributes monthly articles to the CS newsletter. Let me also introduce and welcome aboard Pawan Singhal, General Counsel 3M. Pawan is executive director and general counsel for India region and is based in Bangalore. Pawan is a commerce graduate from Sri Ram College of Commerce, Delhi. He's an associated member of the Institute of Cost and Works Accountants of India, fellow member of the ICSI, law graduate, and member of the All India Management Association. Pawan has rich experience of more than 20 years with MNCs and corporate houses in a wide spectrum of industries, including insurance, pharma, IT, financial services, consumer goods, global trading, as well as areas such as legal, finance, regulatory compliance. In addition, he has practiced in the corporate side with a leading law firm for more than 5 years. Welcome aboard, Pawan. I think you have all your mics. Let's start off. I'll probably sit here instead of standing at the panel. Thank you very much. the topic that we have to read, we have to address is M&A, and these are the M&A savers, GCs across industries who've had the benefit, fortune, misfortune of dealing with external counsels. So I just thought we break this up into 4 parts. While it was originally put at 3 parts, I've made it into 4 parts, just to get to capture the whole of the deal stage, how it goes. I think the first stage is when the commercial teams go in to negotiate the term sheet. Okay, so I just thought, let me put out, Tejal, in your experience, these term sheets, is legal general counsels or external counsels included in these term sheet negotiations, or is it purely a commercial arrangement?
I wish it was one or the other. So usually how these deals take place, and whether it's a large company like ours or small companies, is, if you have a orchestrated M&A where you've been tracking a company for months and you want to buy something and you have your ideas set out, that's great. That's great for in-house counsel, that's great for external counsel. Most of the time they're done over a cocktail, right? We've met somebody, hey, this sounds like a great idea, let's do something together. Or let's, figure out what we need to do. So the important part about term sheet is many of the cases, unless you're a really savvy commercial guy, or you are a BD team, they don't know what terms they're looking at. So they will go in blind. They will try to sign something when a big CEO is in town, or somebody's coming in next month, let's sign this term sheet, without sort of knowing all of the parameters of it. So we do actually, at least for us, encourage that after the commercial teams have gone in, that some version of a term sheet comes to us. The usual answer you get is, it's all non-binding. And so why do we need external counsel? Why do we need internal counsel? Because all of the terms in paragraph number 8 are non-binding. So, ideally, we would like it to happen. I think in 99% of the cases, external counsel is certainly not involved. Not a very bright idea, but they're not. But in GE, since we have a pretty extensive in-house team, we do get a lot of oversight over what gets signed.
Thanks. Vijay, in your experience, I think you'll have looked at multiple jurisdictions. How important, while she said they don't do it, but typically, especially when you go out of India and go into new jurisdictions and you're doing multiple mid-size, small-size deals to do, how important is the term sheet necessary to capture all areas, or all understanding is it? And what's the practice that you all have been able to achieve?
Yeah, so what we essentially aim at doing is right balance. On one hand, the term sheet cannot and should not be as elaborate as, am I audible? Yeah. So it cannot be as elaborate as the definitive agreements themselves. On the other hand, you can't have crucial items missing in a term sheet. So what we look at as a fine balance is that we see whether we are comprehensively covering all aspects, but at the same time keeping language very, very simple and clear and crisp without getting into too much of legalese. And just off the cuff, if I were to give an example, when we say including, we don't follow it up with including but not limited to, we just say including. And if it's an asset purchase agreement and we define what are the assets, we say these are the assets. We don't say, but the assets shall not include this, but shall include this, and so on, and so we avoid all that. So what I'm essentially trying to say is that it is a balance between comprehensively covering aspects, but in a very short and crisp manner.
Thanks. So Pawan, while Vijay clearly put out what should be there, we as external counsels typically face this challenge that you can't tread into this area, it's not part of the term sheet. So thinking of us who come subsequently to the transaction, what should be the key areas that should get covered in the term sheet?
Yeah, that's a good question. What happens is, again, these practices vary from organization to organization. So some companies, like Tejal said, do not create a term sheet, or maybe the legal does not get involved. So maybe a lot of areas which should have been captured in the term sheet do not get captured, right? Because it is primarily driven by the commercial team. But yes, there are instances where legal gets involved, at the right time, and they also provide their inputs in terms of, what else could be or should be covered in the term sheet, and which helps in making it a detailed document. And at a later stage, when the external counsels get involved, they also know that, okay, the key legal aspects which should have been there, whether with respect to, antitrust or HR or labor or data protection, privacy or anything, all those indemnification, all those things are part of the term sheet. Though at a very high level, yes, I do agree it happens only at a very high level, but it does get captured.
Sure. Just wanted to share one experience here. We were doing a deal when it was within India, and actually the transaction was about a set of government contracts. So there were certain heterogeneous services being rendered to the government department. So it was around 10 contracts which had a total turnover value of around 200-300 crores. So the term sheet was entered into, which just said something like government related business, and the manner in which the deal was to happen was not mentioned. So after the term sheet stage, the buyer said, I'll send the draft of the definitive agreement, and he promptly sent out a share purchase agreement telling that I thought it is a subsidiary. So the seller says, no, it's not a subsidiary, all these contracts are housed in the main entity. Then he sends across a agreement which says that there's a going concern which is being sold. Then this guy says, no, it's not a going concern, it was meant to be an asset purchase agreement where the agreement will be followed by a VAT invoice. So if this kind of, the structure of the deal and the manner of the deal was more specific in the term sheet, these confusions are clearly avoidable.
Yeah, I mean, what you're saying essentially is, we face the same thing. I mean, let me just talk experience of private equity also, because we want to, we should have commercial certainty is the key element in the term sheet. So in what you said, a share purchase agreement will have, other than the fact that he doesn't want to sell his whole business, the fact that if somebody wants to sell with asset as a vatable transaction, that adds in Karnataka 14.5% to the value of the transaction, which is not a small number.
Yeah.
I mean, so I think consistency in the commercial is very necessary. I mean, many a time we have investment bankers who are also involved, so it's good to have them at least to close out the commercial aspects. In addition, many a time the term sheet goes to the investment committee or the board of directors who have given a blessing. So then it's your job to close it between that to the definitive, and if it's a deviation from it, it takes its own life and course to sort out.
More importantly, GC has to answer why the clarity was not captured.
Yeah. So I think let's just move on to the next topic that happens in a term sheet and a post-term sheet is the due diligence. And the due diligence, I think, especially from practitioners who are running the business, it's a key element for you all because it has a consequence for post-acquisition effect. And how do you manage the risk post the acquisition? So, in Tejal, in your experience, what are the key elements for conducting an effective due diligence, largely from the legal side, but from an overall perspective?
So the critical aspect of a good due diligence is who leads the due diligence. The problem with a good due diligence is that the person doing the due diligence usually just hands it off 2 to 3 times to the actual person who's going to run the business. And that is where all the gaps occur, even if a good due diligence takes place. So upfront, I think the company needs to identify who are the people who are going to carry this thing forward, even beyond just the due diligence. The second aspect of diligence is how much do you get? The problem always is, obviously, targets in most cases want to give as less as possible. Acquirers want to get as much as possible. When you are acquiring public listed companies, you get no due diligence at all. And the assumption is that everything is in the public domain. So a large part of it is scoping. We found a lot of issues around the correct scoping, where you have these standard checklists also that external firms give you, which are these 150 questions, and they're sort of all over the place. And you have to go back and ask the fundamental question, what is the business of the company and what are you buying it for? And based on that, the entire due diligence scope becomes critical. You can't just send 200 questions to the target and say, answer it, because that is a recipe for disaster. For example, at one point, it's all public, we acquired a company which used to do clinical trials. Now, we did the 200 questions, everything was sent. No one actually asked about good ethical practices of actually conducting the trial itself, which is what was in the papers for the last 2 years extensively and could have caused huge damage to the reputation of the company. So I think those two aspects are key. The third one that always goes wrong in my experience is tax. It just always goes wrong. Because tax laws virtually have no limitation in this country. The tax officer can come back at any point and reach out, on old tax claims. Interpretations of tax are complex. So we have found that in most acquisitions, tax comes back to haunt you.
Vijay, as Tejal put it, broadly touched upon the areas that are key. What, how important is it that to actually crunch it together? How do you prepare the team? How do you coordinate and run that transaction? Because, as you said, if the external counsel has no sense of what you want to achieve, and we want to cover our ass, so we'll put every law in there because we don't want to be held liable for not covering one legislation somewhere. So how do you where's the balance, and how do you the balance versus detail?
Yeah, balance versus detail in terms of due diligence.
Correct.
Yeah. So in my experience, it's like this. No due diligence is a full-fledged exercise. You can't expect it to be exhaustive and foolproof. So that is something which businesses, I think, now have a fairly good understanding about. So we know we are doing a reasonable exercise, but not a exhaustive exercise. So having known that, it is for us to first sit with you guys as external counsel and kind of tell you as to what is the kind of comfort level we are expecting from the due diligence, what are our materiality threshold limits, what are we okay with and what are we not okay with. Because end of the day, any M&A is about a business appetite for risk, and the people at the top who really know the businesses very well, they do it more with a gut feel as well rather than mere tick off on those set of 100 questions which were mentioned. So it's essentially that the philosophy behind due diligence and it's like begin with the end in mind. You should know before itself as to what you actually want to achieve, and many a times what also happens is that the deal documents would have also started being exchanged, drafts would have been started exchanged. So we also try to see whether if there is some gray area in due diligence, could we cover it up with an indemnity and so on and so forth. So it's quite a dynamic exercise, but I think there has to be a balance without looking for 100% exhaustive assurance.
So just one comment I want to, it's working, yeah. Just one thing I wanted to add on this. You can't have any kind of a standard or a typical due diligence checklist. You need to understand the transaction, the deal. You need to understand the business. You need to understand the structure, what you're going for, and then come out with a checklist which does take care of all the key aspects. And then you can work with the external counsel to build on it into further detailing and make it a comprehensive checklist.
I have one more comment on external counsel. Most of the people from an external counsel firm who do due diligence are the juniors. It is really critical in an M&A deal to actually know who is working on your deal and who's working on the due diligence.
Yep.
So one thing that we do as a practice, and I encourage everyone to do, is don't just go to the partner, actually meet and interview the juniors who are working on the deal, because that will determine the quality of work that you're getting through. I know all the partners will say we manage quality, but I think the actual junior associates who go and do the DD are critical to the success of the DD.
And one more thing, if I may add, is that today due diligence is not just about a checklist and a purely legal function and a sharing of activity between in-house and external counsel. Of course, that is very much there, they coordinate together and do it. It's also about trying to see key aspects of the target. For example, if you're acquiring the target for a set of customers, it's imperative that you actually, the buyer goes and talks out to the customers as a part of the due diligence. If you're acquiring them for a set of employees, you have to talk to those employees and ensure that they continue to be with the organization even after post-acquisition and all that stuff. So I think it's quite a multi-dimensional exercise and not just a tick-off list.
So Pawan, let me put a flip side to it. How do you deal with if on the due diligence if you're acting for the seller? And how should we all talk about, nice to talk about the only acquirer, but
right.
many times you'll face that you're the seller also, right?
Yeah.
And how do you deal with such things? And what's the type of information? How you probably
Yep.
know more
Yeah.
than
Yeah.
what they're asking you.
Yeah. That's an interesting area, and yeah, you're right. We normally talk about from the perspective of acquirer and rarely from the perspective of seller. See, in order to make the transaction or the deal happen, yes, as a seller also you have to be quite open and forthcoming in terms of providing the relevant information and documents. Yes, you know a lot which you may not, some of the things may not be divulged, but you have to see, in order to make the deal happen, whatever is required, whatever is asked for, you are able to put it on the table, put it in the data room, and or maybe communicate in your conversations. But like you should know, how much will work. So it is something which cannot be put in on paper. But yes, it's a judgment call when you are getting into a discussion, how much you can convey, and which will help the other side get a perspective of what the nitty-gritties of the subject are. And if there are any further questions, then you need to internally deliberate and see, okay, to what extent we can. But my view on this would be that whether as a seller or as an acquirer, you should be as much transparent, open, and candid about the issues as you can be, so that tomorrow you do not get into trouble.
Yeah, I mean, just to add there, so typically I think you need to bear in mind that there's going to be a reps and warranties which is going to follow in the deal transaction. Every acquirer will tell you due diligence is not an exception to the reps and warranties.
Absolutely.
And then you have to make a disclosure letter.
Yeah.
And if your disclosure letter is different from what you have disclosed in the data room or during due diligence, I think that's one of the big triggers for bad faith. And the disclosure letter comes it's the 11 o'clock document reaching there.
That's right.
Yeah.
And if something hits the ceiling in that time in the night, or when all nerves are already frayed, this is something that needs to be borne in mind.
Yeah.
So you have to be careful that while you answer all of that, you need to take the big picture, so that bearing in mind what the disclosure letter will end up being. Just to add that.
So
one more, sorry.
go ahead.
Yeah, so one more thing to add. This is a very small thing, but typically what we have found is when we start talking to the sellers GC when the due diligence is on, many a time they start many of the activities of putting documents together after the due diligence is started, and that becomes quite a bit of pain because that pulls the length of the exercise. For example, something as simple as the seller has certain properties and we needed the original documents or the khata and the satbara or whatever, and that's not ready, and the seller's GC then tries going to apply for these documents and then getting them. And many a times if you are on the seller's side and if you find yourself in that situation, it can be extremely painful because there are daily MIS reports going as to what is the status of the whole deal. So every day the GC is on the red flag telling that this is not done, this is not done. So I think a bit of preemptive and proactive preparation while the term sheet stage is extremely essential.
Sure. So I think, going to the post-diligence and to the actual transaction documents and how those documents or the contract drives the balance between the parties and shifts the risks or responsibility between the parties is this is the key documentation stage thing. So, Tejal, give a broad perspective of, as a share purchase agreement or an acquisition document, in addition to commercials, XYZ, what should what should somebody look out for on the red flags? I know it's a broad topic.
So the way most of these agreements are drafted, right, people focus on the first 10 pages. That pretty much talks about, we are the parties, we have 4 directors, so on. Then you start reaching the later stages of the share valuation. Some of them have, payments over time. Some of them have, if you have not a pure acquisition, but you have a form of a joint venture, you'll have put and call options. By the time people reach that stage, there's blank, right? So, sometimes I actually say that the pieces that you need to look out for beyond just reps and warranties is the back of the document. All of the stuff that you're not really paying attention to and you're hoping someone in the external firm is looking at. What applies in terms of the confidentiality, what applies in terms of your consequences of breach. What happens in, you can ask for all the reps and warranties of the world, but if the person is going to disappear in 5 years' time, and you're going to fight them in Indian courts, heaven help you to ever get the money back, right? So really looking at things beyond that. The other part of it, I think, that most people forget is the return on that investment. So looking at when I'm going into an M&A transaction, how am I expecting my company to perform after I buy it? And I'm really looking at it from an acquirer standpoint. But even from a seller standpoint, if you've not disclosed correctly and things start tanking, when the company is doing well and you've got your returns in 18 months or 3 years or whatever your window was, it's all fine. But it's the rest of it when it starts coming back saying, how do I enforce this rep and warranty? How do I get my indemnity back? How do I go back and clean up things that I haven't looked at? And those are things I think that we don't pay enough attention to. And the commercial guys certainly don't, because they're working off a financial sheet that basically says purchase, projected revenues, 25% increase year on year. Beyond 2-year horizon, no one knows what's going to happen. So I think that's where I would look at it.
Yeah, I think look at the schedules, look at the earn-out calculation.
But no one does. Those schedules are not prepared also till 11 o'clock at night.
Yeah.
It's only the main agreement that keeps getting negotiated. Schedules are just not prepared.
Yeah, one alphabet in an EBITDA.
Description of land. If you're buying a manufacturing unit, that description of land in Schedule A can kill you if it's not accurate or there's an encroachment or there's anything that's happened there. Dealing with labor and employment issues. All of that is in schedules.
Sure. I think, Vijay, let me put you on the other side of the table again. What should be from the seller's perspective that you should look for to protect your interests as a seller? While, in India, we also take the money and disappear, but,
No, that happens abroad as well.
Yeah,
so I wouldn't carve out an exception.
When things like earn out, a possibility of business, revenue recognition, how do you?
Yeah, so as a seller, probably the first thing I would look at is who are the signatory entities from the buyer's side, because more often than not, the buyer says that he has an SPV or a step-down level subsidiary which will be the buyer, but I would want the parent, ultimate parent also to be a signatory, because this SPV may not have any strength on its balance sheet. Second thing is in terms of some of these what we call as fundamental reps, that it has a good standing organization, they have, they're entitled to enter into this agreement, and the entering into this agreement and consummating the deal hereunder will not violate any law, it will not violate your articles or your charter and so on, and all permissions have to be taken, which have to be taken have been in fact taken. So I would focus more on these fundamental reps, because they go to the very core of the validation of the transaction, like what she was telling, otherwise the transaction itself could be invalid. And if as a seller, if I am looking at deferred consideration, I would try to see how my deferred consideration is structured, whether it has definite yardsticks, whether the results for each yardstick to happen, are they clearly defined. And a lot of nowadays, a lot of times you have escrows, you have multiple escrow structures for different results. So one escrow for say some litigation which is going on, one escrow for revenue to be generated at a particular level. So whether are these things extremely clearly defined. And I would also look at some of these boilerplate clauses which though like what you said, it's 11 o'clock thing, but remedies for breach, what would happen if the buyer doesn't perform his part of the obligation, and so on.
Sure, sure. So I think, I mean, you touched upon fundamental warranties and things. So I mean, I don't know if you had any experience, but Pawan, I just wanted to know if, you know, today in many situations, the private equity funds are the owners of businesses, and they are very hesitant on giving any reps and warranty and saying, we are a limited life company and we have no existence. We want to sell this business and get away. Here, do whatever you all want, but we're not giving you any, maybe only on ownership of shares. So how do you deal with, you know, as an acquirer, if you are acquiring a business and there was a seller of this kind, how do you face that?
Yeah, it's a tricky situation, and especially in today's context where there are a lot of equity funds investing, and after a couple of years, they have their own objective to step out, you know, and get their money back. And at the same time, it is also true that their involvement in the day-to-day management of the company is very minimum. They are not involved in day-to-day affairs, and that is why they are very reluctant to provide any kind of reps and warranties, and they expect the promoters or the management to provide those reps and warranties. So that's a bit of a challenge, but what I understand nowadays, you have this warranty insurance, which is available, which can take care of some of the obligations which may arise in relation to reps and warranties. And as private equity investor, they would rather go with that option rather than taking on or agreeing to take on any of those reps and warranties, because as an acquirer, you will always insist that the seller shareholders should take joint and several liability for all the reps and warranties or indemnification or anything.
So, I mean, yeah,
one more thing, sorry if I may add. Very difficult, as you rightly said, for to expect private equity investors to actually give reps. But what we could do is, firstly, tell the private equity guy that, look, he has to fully cooperate and ensure that the target is cooperating with the acquirer in the due diligence process. So that is somewhere he can actually influence. Secondly, he can give these fundamental reps at least, which is very important for me. That he can't say that I don't know the business, because we are talking of the private equity himself. We are not talking of the target. And the third thing is, we could take, as an acquirer, we insist on a standard rep that, to the best of my knowledge, I have not come across any incident or I do not have any information which could be substantially prejudicial for a buyer.
Yeah, I mean, just in such a situation, I think the diligence process becomes higher. Sometimes, no doubt, that process is sort of inbuilt, presumably because they have the better checks and balances, better systems, better audit, not so aggressive tax positions. Hopefully, you believe that they are going on that. Let me
just one comment, one more point on that. As an acquirer, when you are looking at a target company, and maybe at the initial discussion level, you get to know, okay, who are the investors in those companies, and what their standing is, and what their involvement in the day-to-day management of the company is. So they get a sense of, how many equity investors are involved, what is their level of engagement, etc. So they get a high view of what they're going to get. So it's not coming as a surprise to them when you're negotiating the reps and warranties. Yeah, as Vijay rightly said, that basic reps and warranties, nobody would mind. But when it comes to reps and warranty, which may lead to financial exposure, that is where they are reluctant.
Sure. I think let me just fast forward. I think we have about 10-20 minutes and go into the two related topics. One is, the big topics that happen. What do you do with, like change of law or significant misrepresentations? I don't, without any offense to anybody, like whatever, coal license cancellation, spectrum cancellations. How do you deal with such things? And you're in Delhi, so it may be more.
So I think what has happened recently in India and in the environment has basically changed the whole spectrum of how you actually look at a license or even a policy. So initially, like you mentioned, that you look at, okay, have you got all the licenses? Have you got all the permissions to operate? Have you got sort of your, basic permissions in order. What this has done is basically change the entire focus of, is it fair, has it been transparent, how has it been acquired in the first place, what were your source of funds, and that's taken sort of due diligence to a completely different level. And this is not due diligence that the target is going to give you the answer for. A lot of this due diligence is around, do you understand the regulation? Do you understand how this can come 5 or 10 years later to bite you? And that's something I think is still evolving, because I think, honestly, from a foreign investor standpoint, it has sent shockwaves, right? Because the assumption is that if it's a government auction or it's a, something that has been sort of sanctioned in some way by the government, it should be fine. When you actually challenge those fundamentals, I think it becomes really, really difficult. But it has opened up your eyes in terms of going to the root of it. And to the other comment that you made around, what is it that you're acquiring? If you're acquiring it for something, then you have to go all the way back to check where it came from.
Yeah.
I mean, there could be a lot of peripheral things that if they fall off, if they're cancelled tomorrow, if something, it's not going to bother you. But if it is the fundamental business that you're buying, you'll have to go all the way. And this has become extremely difficult because no one knows what to open up anymore.
Yeah, and I think the law itself on those subjects are sometimes vague and uncertain. So none of us know to give a sign off to saying, yes, it's done properly.
So what we essentially do is, we take the misrep part separately and this kind of licensing subsequently part, that we take it separately. So these are more, business related things which could genuinely happen. I mean, you may not be able to hold the seller responsible. For example, as we speak, 2 days ago, there was a deal which was being contemplated in Bangladesh. It was about a company which was into the streaming and downloading of music. Suddenly the Supreme Court in Bangladesh has passed an order that no non-Bangladeshi music will be Hindi music, Bollywood music, no downloading in Bangladesh, it's illegal. Of course, there are a lot of pirated versions running. Pirated is the norm, that's a separate issue. But I mean, you can't blame the seller for this. So what essentially we need to do is, did the seller have prior knowledge of something like this coming? If he had, yes, you can hold him responsible. But if it comes entirely after the deal, it's your business risk.
It's a significant business risk. No, so
just
yeah.
one. So same way, I think the acquirer also has should do a kind of a recce or a due diligence around, like, okay, what's the environment, the ecosystem where he's doing that acquisition, what are the kind of things happening. So maybe using some consultants or maybe using some experts there and getting a sense of, what may happen in the next, coming months or years. So which will give him a sense of, okay, is there going to be something significant change, some policy change, something which he should be aware of and which will help him in the decision making.
Fantastic. I think, good.
I remember when, not in the context of an M&A, but it was interesting because when we did that Harshad Mehta case, and he used to keep selling the shares, right?
Yeah.
And they were actually tainted shares. And one of the things that they went on in court about was a bona fide purchaser for value without notice.
Correct.
And it was actually upheld in that particular case. But I mean, in an M&A deal, I mean, you're just sort of inheriting it all,
Yep.
even if you're a bona fide purchaser for
Yeah.
value without notice. So it's a very interesting concept, which is not applying really in the real world.
Yeah, true. I think, and also the progression of the law. Now, today with the Money Laundering Act coming into force, why do you, is bona fide purchase of a value sufficient safeguard? Is a question that will get debated again. So come back to the day-to-day stuff which you now deal with every day after acquisition. So the post-acquisition issues that as GCs that you have to deal with on the deal, which external counsel is out of the way and it's totally your baby now to handle. So, I mean, I think there would be issues regarding redundancy, layoffs, integration. Tejal, take up one of them, and I think all three of you all can.
I'll talk about integration in general. We tend to, and I'm going to say this very candidly here, we tend to as GE, because we have a lot of processes, it's very international, we have a lot of standard policies. We come and we completely stifle the target. And we've realized this over the years, right? You come in, you've got to use, my EHS system, my payroll system, my way of working. And we found in many, many cases, the profitability projection is completely gone after buying it. So I think that's the other thing we've learned over time, is that in an integration, what should you do in the first 30 days, what should you do in the first 6 months, and what should you do going forward? And that has to be extremely clear, because otherwise you will end up destroying the entire value for which you have actually bought the company.
Okay. Vijay, you can take up anything.
Yeah, varied experiences. On one extreme, you have a situation like what she was just telling. Other extreme, I'll give you. Actually, there's no integration happening, and even 3 months after the deal, you're telling, why is that still running as a separate unit? I don't know anything about that unit. I'm supposed to be the GC of that unit, and I don't know anything about that unit. So that can be one kind of stubbing factor. And another extreme is, after buying, you realize that what you paid for is not what it is, and you get into not into integration but into litigation with the erstwhile sellers. So, and in between, so that's a wide spectrum, I guess.
Sure, and I think, Pawan, to just pick your brains that today, especially in a Bangalore, which you do a lot of service-related business and not so much hard assets maybe. And when you have the service-related business and you've got people leave, or you want to fire people, how do you deal with this whole issue of layoff, or they're leaving? How as GCs, what are the challenges that you would face when you deal with this or faced?
So yeah, people integration is one of the key elements of any acquisition or M&A activity. And people are one of the key assets when you are doing any kind of an acquisition. And the integration thought process or the planning should start not after the acquisition is completed or the closing is achieved. It should start when you are talking about due diligence, you are planning about due diligence. You need to understand the target company, the culture of the company, the value system of the company, the employees and the way they do business, everything. And then you need to work in your organization, how does it map with our requirements, our expectations, our standards, and what needs to be done when the acquisition is completed. So you need to put a team with the right leadership and skill sets in place with a complete plan, in terms of prioritized activities, what you are going to do, and which has got a significant business impact. And once the closing takes place, you need to make sure that you follow that plan and bring people on board and give them the experience which they will remember forever. That makes a big difference when they come on board, and the way they are welcomed or they are looked upon, that makes a lot of difference.
When you especially spoke about layoffs and redundancies, I think one mistake that we make when we buy companies is assume that you are better than the target you're buying. And that's the biggest mistake we make, because we are buying that target for a certain value that it brings to your organization. So whenever people-related actions are done, it should be done with equal fairness to both the acquirer and the target. And the best people should survive the organization as far as possible, because that is what is going to lead to the profitability. And that is what most acquirers forget, because they always think the other guy is going to lose his job, not me.
I think
one more point which I would like to add on this is, yes, when it comes to kind of separating some of the people who may not fit into your system, it is always good to have a very open and candid conversation with them, help them in finding some alternative jobs, or connecting them to some consultants, etc., and give them time, maybe 3 months, that okay, we will help you with this, you take your time to find a job, and once you are there, then you can move on. So that is something which works very well, and people respect that, that even if I have to leave the company, but the company is supporting me in finding an alternate job.
I think that's a general comment against any layoffs also.
Yep.
But I think we've tried to cover a very wide area as much and quickly as we could, and trying to pick the brains of the GCs. If anybody has any particular questions, any difficult questions, they all represent the wide area of the GC community in India, and I'm also here happy to chip in as an external counsel on any area of M&A.
Hi.
Sorry, state your name and you're from.
Hi, I'm Vinod from Strides Arcolab, Bangalore. And on doing transactions, it always starts with the term sheet, of course. What would you think is the right timeline between even discussing a term sheet and to signing a term sheet and then completing a transaction? Because sometimes, for us at least, when we did a transaction, it went on for 18 months, one particular transaction, and the other transaction we did in 3 weeks. So I have personally a difficulty to understand what exactly is a good transaction.
Disclaimer, pharma industry, I don't think anybody can say anything about what, but I think I would probably say 30 days for signing term sheet. Today, transaction is anywhere between 3 months is a natural expectation, 60 to 90 days. But however, you bring up important things, and which all we have to know is that, you know, the exemption of the 5 years that we all were happily working under with regard to the target on the competition commission aspect, which is the blanket exemption, 250 crores, 750 crores is going in 2016. So any deal is therefore, we have to examine whether it touches those deals, and therefore in that aspect, seeing the acquirer and the target becomes an important question. So that's something that is going to happen. I don't know what you guys think big conglomerates would.
I would just like to pitch in on that also. This especially with regard to the internal controls, where the board or the management gives you the overall dictates of terms that has been agreed over a barbecue or a cocktail, like you said, and then you are expected to come out with a term sheet by evening, so that the management can review it in a couple of days and come back to you. So as a counsel, I find it really difficult to understand the timelines. How fast should I revert back there? How fast should I revert to the target? When should I talk to my counsel? When should I appoint them, bring them on board? So that the timelines is something that I would like to really have an understanding.
I'll comment on that because we do these all the time. This timeline is unrealistic, but I would not allow a term sheet to be signed if your 10 basic terms are not decided. So I think a lot of it is governed by, do you know your 10 basic terms in the first place to even sign a term sheet? You know, I mean, depends on organization to organization, but we basically take people out and say, look, you're not ready to sign anything. I don't care if you want to sign it on Monday, there's nothing to sign. You know, if you want to go and sign a blank sheet of paper and pose for the camera, that's your problem. But, you know, we can afford to say that. So that's one piece of it. The other piece of it is, if you let transactions go on for too long, the entire purpose of the transaction sometimes gets lost. So that, to your point, there should be a reasonable time frame around these things, because people change, priorities change. But with the regulatory approvals coming in, most transactions are going to take longer than we think they're going to take. So that's the other piece. And engagement of external counsel, my suggestion is negotiate the fees very carefully, because if your transaction stalls in between, their clocks are still ticking. And we faced that several times.
Yeah.
Hi, I'm Manish Kia from HDFC Life Insurance. So we talked about reps and warranties, and you know, after due diligence, a lot of time goes into hammering out wordings of reps and warranties, specific warranties, etc., and then indemnity. And eventually, if one day something goes wrong, it all boils down to, are you able to enforce it, or are you able to get anything out of it? So any experience around that, or any word of caution, or what do you really see into that, you know? Because a lot of time it becomes like it's just we have spent hours and days talking about it, but can we really enforce them and get something out of them?
Yeah, so, can I? Yeah, so first thing is in terms of whom you are dealing with on the other side. Like if you're dealing with someone in the US who has already been convicted on 13 counts of felony, you can't expect him to be any more thick-skinned. He's already fully thick-skinned. So whatever beautiful clauses you have, nothing can be enforceable. He will go through it. And if you sue him subsequently also, he will say, okay, let's go through the whole process. And one more thing we need to see is in a typical M&A deal, at least my experience in the US has been that unless you are able to overwhelmingly convince the judges that there has been a fraud, so only then you can expect some meaningful action out of it. Otherwise, it's typically, he will say, okay, try what you want, and then you'll try to negotiate something out of court, and you'll get some pittance. So I think it's a question of a decision taken wrong in the first place. Coming to the Indian context, one good thing that's happening of late is a lot of arbitration going around these kind of matters, which in a way is good, but the problem we face is that arbitrators tend to take a more submissive and chalta hai kind of view, and it's very difficult to make an arbitrator understand what is loss of business opportunity. It's very difficult to make an arbitrator understand that, look, the projected revenues or represented projections were this much, but what we got is only half or quarter of that. So even in India, unless you are able to make out a dramatic case of fraud or some criminal action, it's very difficult.
I am Akhil Prasad, I work for Boeing. I have a question for the panel that one of the important aspects in an M&A transaction is seeking consent from the Competition Commission. And Competition Commission also had a very absurd ruling on the timing when you should go to the Competition Commission to get an approval. So any insights as to if you have faced some situation of the matters going to Competition Commission, what is the timing when you should go, and whether how quickly CCI has reacted?
No, the act gives you the, I think the whole controversy in that happened because of the indirect acquisition. And that's where the trouble is, filings on the indirect acquisition is a little vague, and they're seeking to clarify it. On the direct acquisition, it is quite clear. It's the indirect acquisition which is the challenging one, and which results in a subsequent violation. And I think it's also the philosophy of regulator which has crept in, which to saying that if there is a violation, a fine has to follow. I mean, that's, you would see in SEBI, you would see it in competition everywhere. That's a larger debate which has come in, which is the dangerous one. So,
because we just got our competition clearance, so it's the whole aspect around timing is, there's twofold issues in India. One is, unlike other jurisdictions, you cannot start conversations with the Competition Commission prior to your transaction, to statutory authority. So if you are acquiring a public company and you make a public announcement, their stand has basically meant that is your trigger. And that's still, according to me, open for debate. And in an indirect acquisition, it causes huge issues because your deal is not baked. So there is nothing really to file. And if you actually see the forms that are required by the Competition Commission, they are so voluminous that you actually have had to have done complete due diligence, got complete cooperation from the target before filing. So, but I have found that in terms of timing of clearance, the Commission has been extremely efficient and extremely reasonable in the way that they have dealt with the actual approval process.
and now they're also going very technical, that it's going by the standard regulator practice that your form is not complete. They have amended the forms again, but your form 1 is not complete, and now they've asked for more details on form 1 to actually act faster. So there has been criticism, but I think they're moving. But I think the larger issue is going to come once the exemption goes in 2016, where therefore would the volume of filings increase dramatically, and therefore what's going to be the response in time. Any other questions? Yep.
My name is Jagdish Rao. I represent Shriram Properties. We have seen recently a lot of regulatory issues, particularly retrospective effect issues. Like if you see the coal block allocation, where Jindal was allotted a coal block, and after 3 weeks it was withdrawn by the government, for no reason whatsoever, citing that the promoters were tainted. how do we handle this kind of situation? Because this won't become a force major, and how do we ring fence the company buyer?
I mean, we'll all have to learn through it. No, I don't have any particular insight. I think
particularly retrospective regulatory changes have become very common these days, be it coal block or taxation.
I agree, but who's going to bear the brunt of the shifting of the risk? Is the seller responsible for it? I agree where you're coming from the buyer's perspective. Look at from the seller's perspective. It's as unknown to him as it is.
That's true.
So it's how do you allocate the risk and where do you?
Then who takes the hit then? Is it the buyer or the seller?
No, I think a consequence. Estel, for example, has been given the refund of the money late in the day, but it has come because of the they were holding they're holding spectrum versus license, one of the two. So it is judicious. You have to go and get the writ court is there. You'll have to go through it. There's no answer other than the judicial remedy and the faith in the judicial system. Anybody else? Yeah.
One is when you're actually doing a deal with the government, and then you say change of law is force majeure.
Yeah, I think y'all are, corporates like y'all doing deals with the government would face force majeure.
Change of law is not force majeure.
Yeah.
It's a very interesting dilemma.
Thank you. I think we are just spot on time with regard to the session. Thank you very much. Thank you for the panelists for sharing the insights. I hope it was little insightful and little interesting before your lunch break. Thank you.
Thank you.